Welcome to the Meaningful Mediation Podcast, the place where leading lawyers and negotiators share their best tips and strategies for mediation and negotiation. I'm your host, Patrick Russell, a full-time Florida mediator and lawyer. My goal is to help you have an effective and meaningful mediation. Each episode will provide you with real-world strategies and tips to help you negotiate and mediate with confidence. Let's get to it. Welcome back to the Meaningful Mediation Podcast. This is the show where we talk with lawyers, mediators, and negotiators who negotiate for a living. I'm Patrick Russell, your host, and when I'm not interviewing great guests like I have today on this show, I'm helping lawyers settle their cases as mediators right here in Florida. Today, my guest is Scott Aigen, a Miami personal injury lawyer. Before he ever filed a complaint on the plaintiff side, though, Scott spent the early part of his career defending insurance carriers and the people they insure. That's the conversation I want to have today. What does it look like to negotiate against the side you used to play for? So, Scott, welcome to the show. Really glad that you're here.
Thank you, Patrick. Good to be here.
It's always great to see you. So before we get into this strategy stuff, I want to back up to the moment you decided to switch sides. So people who tend to do this have a story about what made them flip. Tell me yours.
That's an excellent question. I have to go back a few years, Patrick, but I was working at a law school for a defense firm. It was an excellent firm and I was getting great experience. And look, I knew I wanted to be a litigator. I was litigating cases. I was learning personal injury. I was working for the insurance company. I was billing my hours. Everything that I did had to be written down, point 2, point 3, point 4, whatever it was. That to me became a little tedious. And look, I think I knew that I wanted to do something a little more entrepreneurial. I did know that I didn't want to work for the insurance companies. I didn't want to have to keep reporting to insurance companies. And it was just a matter of time. I got an opportunity earlier than expected, and I took it. I took the opportunity and I started representing plaintiffs. And then I went to a firm. I was there for a short period of time, but I went to an excellent firm, started representing plaintiffs. And that was just a whole new world of litigation and just a different way of practicing law. And I ran with it, and I've been doing it ever since.
Awesome. So we share that background of having been on both sides. I did the reverse though. So I jumped into being the entrepreneur first. So I worked in your chair first. Then I jumped on the defense side just to see what was behind that magic curtain for
Nothing
a while.
wrong with that.
Right?
Nothing wrong with that. I
wanted to check that out. But from the defense side, I want to get your impression on this. What surprised you the most about how insurance companies actually evaluate a claim versus maybe what a plaintiff lawyer tries to paint that same claim as?
Yeah. There are some very simple ways that I noticed that sometimes insurance companies are evaluating claims that I think don't really put in a lot of thought into what the plaintiff is actually going through. And when you're on the plaintiff side, that's all you're doing. That's all you're thinking about, is you're thinking about your client and what he's been through and what he's going to continue to go through and what type of medical treatment he has and how it actually affects his life. And you're talking to your clients about that. I think when you're on the defense side, look, you have a limited amount of information. You get to take the deposition, you get to look at some medical records, but you don't really know what exactly the plaintiff is going through. And a lot of times you just don't believe it because you're working for the insurance companies and that's how you're trained to think. And I think just in terms of evaluating cases, they take an oversimplistic view of that case values. And sometimes they're just simply looking at medical bills and taking a multiple of them, and I still think insurance companies are doing that. They're simply taking the medical bills, whatever's outstanding, and maybe multiplying it by 3, or saying, well, there's attorney's fees, and then there's medical bills, and then simply the plaintiff is going to get X amount of dollars. I don't know why they look at it that way. We certainly don't do that anymore, but that's one way that I thought insurance companies really do evaluate claims, so heavy on the medicals, spending so much time on the medical bills. On the plaintiff side, I see the medical bills as just sort of the tip of the iceberg, right? It tells just a small part of the story. It's just what you can see and visualize, but it's not really what's happening in a case. I mean, you have cases where there's medical bills, and sometimes they're not even that high, but you have massive injuries, traumatic brain injuries, broken legs, broken arms, paid for by insurance, et cetera. The medical bills aren't always that high, but you have non-economic damages that are serious. So what I always thought was it's overly simplistic. It doesn't really put a lot of thought into the non-economic uh, uh, um, the non-economic component of the case.
And from your chair now, you live the case, you hear from the client, you see the client. They're talking to you all the time, right? And then from the defense perspective, the only time you're going to see that particular person is when you take a deposition. Other than that, they're just a name in your file, right? And everything is just a number and is black and white. Whereas in your chair now, everything is in color. It's 3D and in stereo, right? So there's a different perspective of those two chairs.
Yeah, I
And I
mean, I
think
always
you're
tell
right.
my clients that when they prepare for deposition, I said, right now, you're just a name on a piece of paper. They don't know anything about you. So a big part of this, of course, in deposition is preparation, and make sure that they're making the right first impression, because that's probably the most important part of any case in litigation, is that they have to make a good impression. They have to make a good appearance, and they have to tell their story. They have to tell their story the way they tell it to me. And now they got to do it under oath with a lawyer grilling them. And sometimes they freeze up, or sometimes they forget something that's really important, or sometimes they say the wrong thing. And those things do happen. But I think preparation is the most important. The most important part is preparation, to make sure that my client tells the story, really gets
Yeah.
it out what they're going through.
So, what did the first year on the plaintiff side teach you that defense work didn't?
Um, well, it taught you a lot. Again, it's a whole different way of practicing law. Um, you're just focused on, again, telling the story for your client, telling the story in a way that the insurance company understands the extent of the injury and what they're going through, and just focusing more on this one person, rather than spending all your time sort of reporting to an insurance company and getting authority for a budget and getting authority to pay X amount of dollars. I think what it taught me was that, and what it taught me was to be more aggressive. That's really the main thing, just being more aggressive. If you're a plaintiff's lawyer, you have to be the aggressive one. If you're in a case and you're just responding, that's not a position
Right.
that you want to be in. You want the defense responding to you. You want to be marching forward with your deadlines and your trial date, and make sure that you're the one that's pushing this case forward to trial. Not necessarily as fast as you can, but developing your case and marching forward rather than getting pushed back. And I think that's what the major difference is between a good plaintiff's attorney, I think, um, practicing as a plaintiff's attorney and being a defense attorney. You have to be aggressive. You have to keep marching forward.
Proactive, not reactive.
Yeah, I mean, if you're reactive in this business, it's not a good position to be in. It doesn't make you feel good, you know? So I think that's exactly what you learned. That's a different way of practicing law.
So, what would be the biggest tactical advantage from your defense background that now helps you at the negotiation table when you're on the plaintiff side? Anything you can think of?
A tactical advantage? That's a good question. Um, I think that when I'm evaluating a case, I'm always thinking, how is the defense reporting? What are they putting in that report to their client? What's it going to say that's going to change the value of this case? Maybe it's a really important expert that talks about a life care plan, and they now have to evaluate it, and they have to analyze it, and they have to send it to their um, to the adjuster, and they have to report on it. Maybe it's a motion for punitive damages that really gets them thinking about what is the value of this case and how are they reporting it. So I don't know that there's so many tactical advantage that I picked up in my limited amount of experience as a defense attorney, because it was limited. Yeah, I learned a little bit, but I know that those things matter. Building your damages and making these insurance companies really, really think about it, being aggressive, right? Taking every single deposition. Don't leave a deposition out. Make sure that you are deposing every single witness that you can find. Subpoena records. Depose the people that are sending you records on issues that are relevant to your case. Line up your witnesses, prepare your case, put them on their heels, right? Be proactive, march forward, put them on their heels, make them have to defend this case in all that we're doing to march this case forward to trial. And, that's going to get their attention. You want to get their attention. And there's certain ways to do that, I think. You know, I certainly think there's ways to do that. And once you've gotten their attention, and I've talked to defense attorneys about this, right? And I've talked to the attorneys that are reporting to their clients about this stuff. I believe that once you get their attention, you make them really worried about this case. That's when you're going to be able to show up to mediation or arbitration and really get the best possible result.
Yeah, it's all about getting them to think about something and something new, perhaps, right?
Could be
Adding
something.
something like you said that they haven't already considered that now they have to further evaluate that may change the case for them. And knowing what that might be and then doing it.
Exactly. I mean, if they came with a certain amount of money, you got to make sure that you gave them every reason to bring the right amount of money to the table. And then, of course, getting that out of them and getting them top dollar. I mean, maybe you don't take it and that's fine, but at least if you're going to go to mediation, you got to make sure that you went in there with the right plan, that you were fully prepared, that you made sure that the defense was prepared. And I think maybe not all lawyers do that. You have to make sure that you are providing the defense with all that information before mediation long enough so they have time to roundtable it, because they're going to sit there, they're going to think about it. They have to talk to their higher ups, whoever's in charge at the insurance company making the calls as to how much money to pay on this case. And you got to make sure they're talking to the right people so they come to mediation with the right amount of money. So there is some strategy to do that. Again, I mean, it's preparing the case, it's taking the depositions, it's getting your experts already aligned. I think timing of mediation is important too. You don't want to do it too early. You have
Mhm.
to time that. Maybe it's a month or 2 months before trial where they got a lot to worry about. They got a lot more money to spend. So I think it's all those factors that really matter.
And a key component of what you just said is really, really important is getting that information to them well before mediation. So somebody's had the chance to analyze it and then factor that into whatever money they bring. Because if you bring this to mediation, while it may be relevant and interesting and could impact the case, the decision has already been made before that, what number they brought, right? So you need to get it to them well in advance of mediation.
Yeah, if you want to settle at mediation, I mean, sometimes you don't.
Mhm.
I mean, sometimes you go in there and maybe you're not going to settle, and you go there to make a point, and you're going to walk out and you're going to prepare your case for trial, because once you get closer to trial is a much better opportunity to settle for more money, or you just feel so good about your case You're prepared and you're going to go try it. But I do believe that, a lot of cases do settle at mediation or maybe shortly thereafter. And if you're fully prepared to do that and your client's on board and your client gives you the authority and you think it's the right deal at the right time, well, if you're going to do that, then you better make sure you're getting top dollar and you're
Hmm.
getting every penny out of them that they've brought or more.
Walk me through how you build a demand letter. Um, knowing what you know about how the defense side reads them, what do you put in it?
A
What do you
demand,
leave out?
you're talking about a demand letter before mediation?
Yeah.
Yeah, I mean, we spend a lot of time doing just that. That's a big part of what we do. I mean, I take
Uh-huh.
that very, very serious. I never walk into mediation without having my story ready to be told, having the documents ready to be presented, and having my experts in line. Yeah, you really have to have your experts ready to go. And you got to get on the phone and talk to them. You're going to have various reports. Maybe the reports aren't final, but you got to be prepared to explain to the insurance company, explain to the defense what this case is all about. And when this case does go to trial, my expert's going to take the stand and here is what he's going to say. And you have to take the time to look at, well, maybe it's a retained expert or maybe it's a treating surgeon, you know,
Mhm.
what is that expert or what is that treating doctor going to say? And most importantly, is it consistent? Have they talked? Do you have a life care plan that's going to talk about all the needs of somebody that's suffered a catastrophic injury? So you have an expert there, and then you have a treating doctor. They're both going to have to take the stand. Are their stories going to be consistent? So it's a lot of preparation to do just that. Before I do my demand letter, I'm working on that kind of stuff. I want to make sure everything's linked up. I want to make sure that the story is being told in the right way. And I want to make sure that I'm also, most of the time, using deposition testimony from the defense against them. So we're analyzing that, finding lies, misrepresentations. We see that all the time. Finding witnesses that are saying things that just aren't true and no one's going to believe. And you got to be ready to explain that to them and look them in the eye and saying, this witness here, you're going to have a problem with him. Or this witness here that is extremely important. Here's what he's going to say, and it's favorable to us. And that's going to be a problem for you. So if I'm doing my demand letter, that's really my time. Most of the time, I would say it's my time to get this all ready to go, to package it up so I could have the best possible result at mediation. And again, maybe that's not settling the case, and that's okay. I think sometimes a
Yeah.
good result is not settling. I mean, I know the mediators, I think they like to settle these cases, right? I mean, I don't know if you're keeping track, but sometimes I think that it's really good to walk out. That sometimes is the best possible result.
Well, believe it or not, in my mind, a successful mediation is where it's not necessarily a settlement, although that's wonderful. It's if the parties make their own decision that this is either a good deal or not, but they know what it is. They've came, they tried, they worked hard. They just disagree on whatever that number may be. But they know the risk going forward and they decide to call it a day. I call that a successful mediation. But where people don't participate in that process, where they don't really negotiate fully. They haven't offered all of their authority. They've kept their cards hidden. They're waiting to launch a surprise down the road, and nobody knows what's going on. There's more questions than answers. That's probably not a great mediation.
Yeah. Well, I do
If I don't
actually.
win it, I don't really measure them according to settlement or not, although those are nice to keep track of. That's not the ultimate goal.
Yeah, no, I do agree though, to a certain extent, right? I mean, sometimes you don't want to show your hand. Sometimes
Mhm.
you got something. There is some strategy there, of course. I mean, I'm talking about all the work I do to prepare for mediation. We do all those things, but sometimes you're like, you got to maybe keep a few things in your back pocket because you're going to have to cross-examine their expert at trial, and you don't necessarily want to show them everything. So that I think there is an art to that. But again, sometimes you don't want to settle at mediation. Sometimes a fruitful mediation might be getting some information from the defense.
Hmm.
Sometimes I think they share a little bit too much information. You know,
What's wrong with my case, right?
right, right. Um, Sometimes it's helpful because maybe it's a really difficult case. We do have some of those. We do have some that I do really want to settle sometimes. And you have a client sitting there, and maybe my expectations and their expectations aren't fully aligned. I think once they hear what the defense has, that gets them thinking a little bit. That can be extremely helpful,
Yeah.
in terms of client expectation and what they're going to be facing at trial. And maybe it's a really good defense attorney who's got a good strategy for presenting this case at a mediation. Um, I think that can be helpful sometimes. Sometimes defense attorneys come in and they don't want to say very much. Um, Nowadays we're doing it on Zoom. Sometimes they're not even in the screen and their video's off. I don't think that's effective. I do like when a defense attorney, I think from my perspective, does a lot and tells us a lot and gives us a lot of information. It helps sometimes to get a case resolved and to talk to your client about some problems that they might have with the case.
I think that information sharing goes on the Mount Rushmore for mediation, right? That's one of the things that's key because without information, people can't make decisions, so you need to do that. Now, let's talk about Florida. It's big, it's got a varied jurisdiction. Miami juries don't behave like those in maybe Jacksonville. So carriers know that. How does venue factor into how you negotiate a case?
That's a good question. We do the cases all throughout the state of Florida, and venues vary. I think that sometimes that can be a little overrated. You worry so much about the venue and maybe which way they lean. Are they more conservative? Are they more liberal? We're in Miami-Dade. It used to be the most favorable jurisdiction in the state of Florida. Not so sure exactly anymore what it is and what people are thinking from a political standpoint down here anymore. And maybe it doesn't matter. Maybe some of that stuff is overrated. I think that if you have a compelling story to tell and you have a serious accident and you have a catastrophic injury or something serious, and you can tell your story in an effective way, I don't think I get all that concerned about it. I think political views and jury pools and venues can sometimes be a little overrated, depending on your case, maybe depending on your client, what their background is, you know, whether they speak English or only Spanish. Maybe those
Mhm.
are some factors that you need to consider. If you're up in Jacksonville, we just had a case. We were in Port St. Lucie. My client was Spanish speaking only. It was a very solid liability case with a serious injury. Lovely clients who did speak English, I think very, very well, but they were more comfortable in Spanish. And I said, okay, but just keep in mind, this isn't Miami-Dade County. We're up in Port St. Lucie. The jury that you're going to get there is going to look a little different, and they're going to hear your story through a translator. I mean, that's something certainly that I think, absolutely need to consider. Um, but not too much. You got to feel strongly about your case and that this jury is going to have sympathy for your client. Yeah, Florida, Florida is just Miami-Dade's like a little bubble, and then you go to Broward, maybe it gets a little more conservative, then you have Palm Beach, and, then everywhere you go, it's a lot different than Miami-Dade. I think Miami-Dade's almost like a little bubble right now. But again, like, things have changed here too, right? So you don't really know what you're gonna get. I don't try to overthink that, I guess is what I'm saying.
Okay. It's a factor, but not a determining factor.
Yeah, I think it's always gonna be some factor, but again, if you feel strongly about your case, you can't worry about that too much. You have to be ready to tell your story.
Yeah. So let's pivot over to the next segment, which I call the defining moment.
Okay.
Okay. So every lawyer I talk to has a case, sometimes from years back, all depends on the lawyer, that quietly change the way they negotiate or approach the law. It might not have been the biggest verdict or some headline. It might just be one that taught you something you've been carrying ever since, a lesson, a value, something. Is there a case like that for you? And if so, tell me about it.
Well, there's a lot of cases, I think, that are like that, that sort of change your perspective and really you start thinking about, well, what is the value of this case? And how do I explain that to a jury so they'll understand? And we touched upon it a moment ago because sometimes you have a very serious injury and the economic component of it is just really not there. So you have some decisions to make. I mean, there is one in mind. It was a big confidential settlement. Um, well, there's a couple that I have in mind. Um,
They share a common theme, though.
yeah, in a way. One common theme, again, we've touched on it, is like, how does this affect somebody's life? How does it make them feel insecure? How does it affect them emotionally? And I don't mean like they're talking to a psychologist about it, but it's like an insecurity. It's a feeling that they don't like. Maybe it's a really bad scar on their face or on their chest or even on their leg. And, you're looking at this case and you're thinking about it and you're thinking about the kind of impact a scar on your face or a scar on your chest could have, and how it affects you every single day. And you wake up in the morning and you take a shower and you get dressed and you're thinking about it. And it gives you this sense of insecurity. Um, but those are hard cases sometimes because, again, maybe there's no real economic component to it. Maybe
Mhm.
the medical bills aren't massive. Maybe they're minuscule. I mean, we just recently had a case. It was I'll call it a seven-figure settlement. Um, it settled right before trial, and my client was extremely happy with the result. And it was an excellent result, but it was a tough case because you're talking about a big, big number that we were asking for and anchoring, right? How do you explain it? What are you anchoring these non-economics to? We did a demand right now recently on a very substantial case, uh, catastrophic injury where my client is effectively blind as a result of an incident that happened a few years ago. Medical bills aren't that high. There's a workers' compensation lien. It's not all that impressive. We're asking for a big, big number, and we feel really strongly about it. But what do you anchor it to? And I know how to tell that story, but I think what you learn over time is how to anchor and what are these numbers related to. These numbers are not just made up. When we ask a defense attorney or the insurance company or a jury ultimately for these numbers, how do you tie it? What do you tie it to? How does it make sense? How does it make sense?
How do you? Give me an example of, not specifically, but what would you tie it to?
What would you tie it to? Yeah, that's a good question. You tie it to um, the emotions. Look, you do have some numbers, right? So it's not, you have an economic portion of this thing, but the economics don't lead up to that big non-economic number. So what are you looking at? You're looking at telling the story about what this person has to go through every single day. We have a day in the life video, for instance, on
Okay.
this case. I think that helps a lot because it really puts you in the shoes of what this person is going to be going through every single day. If you could find a number, a minimum wage number, which is some technique that I don't love that technique. I know some people still use it. But if you could find a way to put a dollar amount on what it's like to live in this person's shoes every single day for the rest of their life, that's one way to do it. Now, does it add up all the way to that number that you're asking for? No, I think that you just have to really paint the picture of what it is to live every single day in this person's shoes and that can be powerful. And again, this day in the life video, you take a look at that, I think your jaw will drop as to how this person even gets through the day. And sometimes they can't even get through the night, Patrick, because
Yeah.
they're they can't sleep. They can't sleep. It's keeping them up all night and all day, and it's torture. And I think that if you're able to actually see that and visualize it and present it in an impactful way, um, that's a good way to get the numbers that you want. So there's always cases like that. There's always cases like that. Um, and it really gets you thinking. I mean, those are the big ones. You try to take some
Mhm.
of those techniques and apply it to maybe not all the big ones, but the small ones too. And I think that's the best way to build your case. You really have to learn from these catastrophic incidents and maybe apply some of these techniques to all your cases and storytelling. We spend a lot of time on storytelling. I think that's extremely important part of what we do.
Well, ultimately, if you get to a jury, that's what it's all about. They need to hear two competing stories, and they're the ultimate critics who decide which story they like better, yours or the other side. So you better be good at storytelling, right?
Yeah, I think so. I think so. And I think, as a plaintiff's attorney, not to knock defense attorneys, there's lots of good defense attorneys with lots of great experience that could tell a good story as well. But I think that the plaintiff's attorney's job is to tell the story while the defense is just sitting there poking holes or attempting to do so. Right.
Yeah.
And if you have a really good story to tell, then trying to poke holes in it, I think oftentimes is going to backfire. And I'm thinking of a case right now. I mean, they're picking apart his life care plan. Okay. I mean, good luck with that if your goal as a defense attorney is to go in there and say that this injury is not as serious as what it really is when you've told that story and you've seen the day in the life. So,
Mhm.
yeah, I think storytelling on our side, of course, is the most important thing that you could do, whether it's a mediation or a trial.
So let's touch upon what I call the mediation toolbox. So, what tools and strategies do you go to for mediation? Now, you may have already mentioned some of them, but give us, your top 3 or 4 tools for mediation that are essential. Gotta bring and gotta demonstrate.
Well, I think, yeah, we've touched on some of it. Preparations, number one. Be prepared. Be fully prepared to get in there and tell a story. I like to do that. I like PowerPoint presentations and I like to talk. And I like to make sure that I have all the evidence and it's all prepared, at least the stuff that I want to present. I like to show them the deposition testimony that they need to be worried about. I like to show them that report from the surgeon that they need to be worried about. I like to blow up some trial graphics and get that
Mhm.
prepared to show them what we're going to show to a jury here. And so I think preparation is number one, is the most important thing you got to do. Um, Something else, I like to aim high. Shoot for the stars. Don't be afraid to ask for a big number. It's not going to backfire. What's the worst thing that can happen is that you walk out and that you continue negotiating later on or go to trial. Aim high. Ask for that big number and explain, like we kind of talked about before, how you get to it and why a jury is going to award that amount and why they need to be concerned about that.
Mhm.
So I like to do that. Look, sometimes you got to come back down to reality. That happens. Not saying it's not
Sure.
realistic. Sometimes it's not. Okay, I'll admit that right here. Sometimes you ask for an unrealistic number, but if you don't do that, then how are you going to know what they brought? Look, sometimes,
But the important point, though, is that you're still demonstrating to them how you got to that number.
yeah,
It's not you just didn't pick it out of the sky and throw it there. You're demonstrating your math, so to speak, behind the scenes with your story,
you got to be able to back it up.
explaining it.
If you don't back it up, then they're not going to take it seriously. So again, sometimes
Uh-huh.
maybe it's much higher than what it should be, but you'll have an explanation. Maybe it's punitive damages. I think a lot of these cases, you'll see, I mean, some of the negligence is so egregious that you could take a shot at punitive damages, and that changes the whole ball game if you have the right defendant, something that they really have to be worried about. The defense wants to protect their client from that, you would think. So, and that changes the game. So maybe that's a reason right there. Maybe it's spoliation, and you feel confident about spoliation. You're going to win on this issue. Liability is no longer an issue. Maybe it's a liability case. I'm saying it's going to be liability is no longer an issue because of spoliation. And we feel strongly about that. And here's why. But I say, whether it's that, have a way to back it up, but still aim high and stay high and test the defense and see what they've brought. If you start moving too quickly or making moves, I think early on that are going to suggest that you're willing to accept a lot less than your original demand, then that signals things to the insurance company. I don't like to signal anything, especially too early. So I say to aim high and back it up and be prepared to walk out. And if you have to come back down to reality because maybe your client's sitting there saying, I want to get a deal done today, Scott, get me a deal done. Those are things you have to consider too, because ultimately, right, it is the client's authority. So there's always that at play as well. The third thing is I think, insurance companies will try to wear you down.
Mhm.
You have these mediations that go all day or beyond, and sometimes you're sitting there thinking, can't we just get to the point here? Can't we just, what's going on? I'm asking for all this money and they're moving up by these tiny increments. Why? Why are they torturing us? Why are they torturing my client? My client's sitting there wondering and all upset. And I think that the insurance company knows that they're upsetting my client. And that has this sort of psychological effect where they start thinking, well, let's just get to the point and let's just cut to the chase. And I think, look, there's a school of thought that says, let's just cut to the chase. Can we just move on? I
Who
think that
blinks first?
right. If you do that, I think that puts you at a disadvantage. I know it does. I know it does. And you have to be prepared to be there for the long haul. If you're going to get top dollar and get all the money that they came with, then you gotta be prepared. You can't get worn out. You can't let them wear you out. You know, you have to stay focused, and you have to sometimes manage your clients a little bit and tell them that this is all part of the process and manage their expectations while you're getting these small offers and they're getting upset and the mediator's coming back and you're all excited for this big offer and they come back with something small and then your client's all upset and they can't understand and they just want to get it over with. There's a lot of emotions going on. And you have to manage that, but I think you have to be confident in your position, be ready to walk out and don't tire out. If anything, try to do it back to them. Get them tired out. Have them show their hand. I love that in mediation where I start getting an idea. I think they got this amount, and then doing everything you can to get that.
Yeah. Good. So this is the final segment. This is the top 3 tips for better negotiation outcomes. So these 3 tips, try to be specific, not necessarily like prepare,
Mhm.
but what are some good techniques or tools that you've used to get better outcomes for negotiation that are essential?
Are we talking in mediation or before mediation? Mediation,
No,
whatever.
this is for negotiation. So negotiation takes place in mediation. It also takes place outside of mediation.
Okay. Well, certainly you have to have your experts in line. So to be specific, get your experts in line. If you think you need another damages expert, that's big, right? That's something that the insurance company will consider. I think, look, we've all made the mistake maybe showing up to mediation without your experts. And, there's one expert that will make a difference. The insurance company will consider it most of the time. If it's the right case and it's the right expert and it makes sense and it's a really good expert that's been prepared and has a really good report that can explain to the insurance company this case has a significant value and here's why. And I've been doing this for 30 years and I'm going to impress a jury with my report about damages. That's, I think, extremely important and hopefully a specific enough example to do that. Um, while you are in mediation, um, something specific. I like to bracket to try to narrow the gap a little, but also I like to make sure that my top number I'm still aiming high
Mhm.
and I am not coming down at any point in time until it's strategically the right move. It's a bit of there's a lot of sort of chess and strategy with these things. Um, but in terms of specifics, I like to do that. Look, some of these times you're just so far apart. You're just so far apart, and you got to really cut to the chase. And I think bracketing is a very specific way to test the insurance company to see what they have. Oftentimes, you'll see they'll bracket back, and I think sometimes when they do that, from my experience, that shows what they've come with. And, throughout the mediation, they can adjust that a little bit. But I really do think that most of the time doing that and forcing them to respond with their own bracket and their own range, I think tells you a lot. You can get a lot of information out of doing that.
It's reality testing.
Yeah, I think so. Sometimes it's not reality, though. I mean, sometimes they're still going to give you the same nonsense and not really give you a bracket that's realistic to the value of the case, which is okay. All of these things are okay. And again, I mean, what are the numbers? What do you think? How often, what percentage of these cases are settling in mediation? What do you think?
From my perspective,
Yeah.
it all depends on the parties.
But of all
I
the
mean,
mediations that you do, what percentage do you think you settle?
well, there's an issue with that because because some of them are first party property cases, and those have not been settling for a while now because of the new law change. So it's been very hard to settle those cases. So that kind of has thrown things off. But I would say if you get two motivated parties in a personal injury case
Yeah.
and they've done their homework like you suggest, you've got at least a 70% chance of settling the case, I would say.
Wow, that's high. That's higher than I thought you were going to say. Okay.
But remember my caveat, both parties come in prepared and they are also willing to settle. Some don't. Some want to just use it as a discovery tool. Some want to go to trial. It all depends on motivations. But I'm saying if both parties come in motivated and have done their homework and prepared, they may have their differences in numbers, but then again, they can adjust it and they do their reality testing and then they could actually resolve the case.
Right. You've had some interesting ways of evaluating cases and values. How
Yeah, and under like kind of a risk assessment analysis.
do you talk about that on your podcast?
Not yet, because this podcast is about you. So,
Well,
okay.
it's good
So
to
those
have
are
that information, though. I mean, I think that a really good mediator can help a lot. You know,
yeah,
again, you have those very difficult cases, and what are my tactics too? I mean, I'll tell you as well. Sometimes I'm talking to the mediator. Sometimes something that I do, I think effectively is talking to the mediator, not just getting the mediator to talk to the other side and say, "Hey, You go tell them to give me more money. I mean, that doesn't always work, right? The insurance company defense comes with a certain amount. And I think the way the mediator talks and what they say in the other room does matter. I think it also matters when the mediator talks to my client, right? Like that can be effective. And so there are some of those cases, and what we admitted it, sometimes you do want to settle, and sometimes we need to have a little talk with our client and explain to them some of the risks that they are facing if they don't settle. Or look, there's X amount of dollars being offered here. Um, Here are some of the risks for rejecting that. Maybe there's a motion for summary judgment and the clients don't fully understand. I think that having a good mediator and me speaking to the mediator, I like to do it before a mediation, have a little conversation, get the mediator on the phone, talk about the strengths of the case, talk about some of the weaknesses of the case, talk about the client a little bit. So the mediator is invested and fully understands the big picture here. And that can be an effective way of getting mediation or settling at mediation.
For sure. And I was going to mention this, but you mentioned it first. I would encourage parties to use the mediator. Use the mediator almost as a strategy negotiating coach,
Right.
because the mediator's in both rooms. And if both sides are willing to trust the mediator, which I hope they are because they retain the mediator for some particular reason, and you share some of your strategy, which obviously isn't being shared with the other room, but we know both sides, we can help you get to an area, hopefully. Or we can also determine that this is not going to go anywhere and we can be more efficient with our time. Either one is good, right? I think the worst scenario is where everybody spends all day there. Nobody is sharing with the mediator where they're going. And then ultimately they get frustrated because they haven't made any headway after your long, arduous mediation, right? When it could have been possibly resolved or the time shortened
Yep.
had you used the mediator more. So I encourage parties to use the mediator, trust the mediator. That's what we're there for, not just as a number runner, right? I mean, we can do that, but I'd rather you use us as a coach, as a confidant, and to see if we can bring the two sides to where they need to be.
Yeah, I agree. I mean, there are some times where the mediator is going back and forth, and sometimes it's very smooth. I think that's few and far between. It does happen. And look, you worked it out and it was relatively quick and you got the best number and everybody was being reasonable. Happens sometimes, not a lot, but most of the time, I think you're absolutely right. You got to do that. You got to trust the mediator and be able to explain some of the issues in the case. Maybe it's a legal issue. Maybe it's summary judgment that one of the parties is facing, and maybe we're moving for summary judgment. A lot of times the defense is moving for summary judgment. I have to explain why they're going to lose, and there's no chance of summary judgment. And but maybe in the other room they're looking at it and thinking, well, if we don't settle today, we're going to win. But I have to explain to the mediator and get the mediator to explain to them that there's no chance, and don't even think about it today. And I think a good mediator with a lot of experience can go in there and have a lot of credibility so that adjuster isn't thinking that this motion for summary judgment that the defense really has any chance whatsoever. So I do that a lot. I do like to talk to the mediators. I do like to get on the phone and explain all the factors and what we're up against before we actually get in there. That really can make a big difference.
And continue that process, though, during mediation,
Right.
right?
Of course.
And I've got one bonus question just because of what you brought up.
Go.
So, what's the best advice you would give a mediator to help you with your cases during mediation?
The best advice. You got to spend some time and know the case a little bit. I think the mediator is maybe relying on the summaries that the parties are sending and looking purely at that. The best advice is to spend the time, get on the phone with the parties before that, and to really understand everything that's going on in the room on both sides, and maybe be able to explain effectively to both sides what's going on in both rooms. I like when a mediator is able to come to me and explain to me sort of the dynamic in the room. Who's calling the shots? Who's making the decisions in there? What's their background? What are they thinking about? That helps me quite a bit. And that certainly helps me explain things to my client when I have like a little bit of insight as to what's going on in that room. We caucus, we're in separate rooms. My client doesn't really understand exactly what's going on in that room. And the only person they can talk to that does know anything about what's going on in that room is the mediator. So I think what I do like when a mediator is able to give me a little bit of insight on the strategy, of course, without divulging any confidential information, as of course you're not going to do, but to give me some insight on the strategy, how they're looking at the case, how they're evaluating the case, what numbers that they've crunched in order to get to a value of the case. That can be so effective. When I understand, and we talked a little bit about my experience, my limited experience as a defense attorney and how we evaluated cases and sort of this overly simplistic method. Well, are they using that? Sometimes I think that they are. But if they're not, then what are they looking at? What factors are they looking at to evaluate the true value of a case? And that can help me in my negotiation for sure.
Perfect. All right. So, okay, Scott, before we sign off, for anyone listening who wants to follow your work or send you a referral, where's the best place for them to find you?
Well, if you want to follow me, we are on Instagram, Facebook, LinkedIn. You can find me there. Aigen Injury Law, AIGEN Injury Law. What I tell people, just give me a call. Call us. If you have a referral, just give us a call. It's the best way. You'll always get me on the phone. I'm happy to talk about any case, anything that you want. Phone number is 305-533-1600. And I look forward to hearing from you.
All right. And do you have a website?
AigenLaw.com. You can find
Very
us
good.
there.
Excellent. All right. Well, if you enjoyed this episode, please hit follow on Spotify, Apple Podcast, or wherever you listen. And if you're watching on YouTube, go ahead and subscribe and drop a comment. This has been the Meaningful Mediation Podcast, and we will see you then next time.
Thank you, Patrick.
We hope you enjoyed this episode of the Meaningful Mediation Podcast. If you did, be sure to like, subscribe, and comment. Additional episodes can be found on YouTube and your favorite podcast channels. Until next time, less dispute, more resolution.